I want to share with you some special tips and information that are just for cannabis industry clients and businesses that relate to protecting trademarks in this growing field. Cannabis trademarks are unique in that there are issues with federal registration, and so it is one particular industry where state registrations are rather common, at least in the states that allow for cannabis registrations, and I'll get to that in a moment. The U.S. Patent and Trademark Office is still governed by the federal laws on cannabis, and so they will not allow registration of any trademarks that are used in violation, so to speak, of the Controlled Substances Act. And this presents a conundrum or a difficulty for the cannabis industry. However, there may be auxiliary services that are provided by your business that can be registered with the Patent and Trademark Office. So selling apparel or providing a website with information on it are products or services that don't directly involve the sale or transport of cannabis, and so they're not governed by the Controlled Substances Act. So we have had some success registering clients in that manner, for registering trademarks in that manner for clients. For the cannabis goods and services themselves, since they cannot currently be registered at the USPTO, state registration is really the only option. And right now, California, Washington, and Oregon have amended their state trademark laws to allow for registration of cannabis marks for cannabis goods and cannabis services. So this is a vital protection for businesses that are engaged in this industry in one or more of those states to take advantage of. You must be licensed by the state as a cannabis service or manufacturer, and you must be using the mark in commerce in order to qualify for these state trademark registrations. So this area is really growing and changing rapidly. We're doing our best to keep up with the laws and stay in touch with the continuing education. If you have any questions, feel free to reach out.